In the shadow of the crumbling Roman roads of 12th century England, a group of 12 ordinary men from the village of Kingston-upon-Thames stood in a makeshift courtroom. They were not knights nor clerics, but farmers, blacksmiths, and weavers, men whose lives were tethered to the soil and the whims of their local lords. Yet, on a cold October day in 1166, they were given an extraordinary task: to determine the guilt of a man accused of theft. No trial by combat, no ordeal by water or fire, just their collective word, their sworn oaths, and the weight of a king's authority. This was the first recorded jury trial in English history, a moment that would ripple through the centuries. But beneath the surface of this seemingly democratic act lay a system as flawed as it was revolutionary. To understand the birth of the jury, one must first grasp the tangled web of medieval England. After the Norman conquest of 1066, William the Conqueror had imposed a rigid feudal hierarchy, where local lords wielded near absolute power over their tenants. Justice was a commodity sold by these lords, dispensed in manorial courts where fines could be extracted for everything from grazing rights to marriage disputes. King Henry II, who ascended the throne in 1154, saw this system as a threat to his authority. His kingdom was a patchwork of semi-independent fiefdoms, each governed by its own rules, and Henry wanted to centralize power. Enter the Assize of Clarendon, a legal reform enacted in 1166. Henry's solution to the chaos was a bold one: replace arbitrary lordly justice with a standardized system overseen by royal officials. At the heart of this system was the presentment jury, a group of 12 local men who would swear to reveal the truth about crimes in their community. These jurors were not passive observers, but active participants, tasked with investigating disputes and providing evidence. For Henry, this was a masterstroke. By empowering common men to enforce royal law, he could bypass the lords entirely. Yet this experiment in justice was as much a political weapon as it was a legal innovation. What made Henry's juries so radical was their dual role as both investigators and witnesses. Unlike modern juries, which hear evidence presented by judges or lawyers, these early jurors were expected to gather facts themselves. If a man was accused of stealing a cow, the jury would scour the village, questioning neighbors, examining hoofprints, and even confronting the accused. Their oaths were not symbolic, they were binding. If a juror lied, or worse, failed to uncover the truth, he faced the same punishment as the defendant. Hanged for perjury? This system was both a marvel and a menace. For the powerful, it was a tool of control. Henry's agents, known as justiciars, would travel the country, summoning these juries to root out crimes, and more subtly, to root out dissent. A lord who resisted royal authority could suddenly find himself accused of treason, with a jury of his own tenants sworn to deliver a verdict. For commoners, the stakes were just as high. A false accusation could lead to exile or death, while a juror who hesitated to accuse a neighbor might be branded a traitor to the king. The system's flaws were glaring. Jurors had no legal training, no impartial judges to guide them. Their verdicts were swayed by fear, favor, and local grudges. In one infamous case from 1174, a jury in Yorkshire acquitted a serf accused of murder after the local lord bribed them with a year's worth of grain. Henry's response was swift. The jurors were hanged. The message was clear. Justice, in his eyes, was not about fairness, but obedience. By the 13th century, Henry's juries had spread across England, becoming a cornerstone of the common law system. They were no longer limited to criminal trials. They resolved land disputes, settled tax disagreements, and even determined the validity of marriages. The Magna Carta of 1215, signed under duress by Henry's son, King John, enshrined the principle that no free man could be deprived of his rights without the judgment of his peers. Yet this progress came at a cost. The system remained deeply unequal. Women, the poor, and the uneducated were excluded from juries, their voices erased from the process. Legal representation was a luxury few could afford. Peasants had no lawyers to challenge the evidence presented by jurors who were often their social superiors. And while Henry's reforms curbed the power of the lords, they also entrenched the authority of the monarchy. A juror who delivered a verdict the king disliked could find himself accused of corruption, or worse. By the 17th century, the jury system had evolved, but its roots in 12th century England remained visible. The American colonists, inspired by English common law, enshrined the right to a jury trial in the Seventh Amendment. Yet even as juries became symbols of democracy, their medieval origins, marked by coercion, inequality, and political manipulation, were often overlooked. Today, juries are celebrated as a bulwark against tyranny, a way to ensure that justice is not decided by the powerful alone. But in 12th century England, they were a tool of Henry II's ambition, a means to consolidate power under the guise of fairness. The first jurors of 1166 did not see themselves as pioneers of democracy. They were villagers dragged into a king's war for control. Their oaths were not acts of civic duty, but acts of survival. Henry's experiment worked, but only for some. It gave birth to a system that would evolve over centuries, shedding its most oppressive elements while retaining its core idea, that ordinary people, not just rulers, have a right to shape the course of justice. Yet as we sit in modern courtrooms, hearing the words, "You may proceed, ladies and gentlemen of the jury," we should remember the long, tangled history behind those words. The jury trial is not just a relic of the past. It is a living testament to the struggle to define justice itself. In the end, Henry II's legacy is a paradox. He sought to control his kingdom through fear, yet his juries became a symbol of freedom. The men of Kingston-upon-Thames, those 12 farmers and weavers, could not have predicted that their verdict in 1166 would echo through time. But as history shows, even the most flawed systems can sow the seeds of something greater. And so, from the muddy roads of medieval England to the courtrooms of today, the jury's journey is one of power, paradox, and progress. Thank you for watching. If you found this story compelling, don't forget to like, share, and subscribe. There's so much more history still to uncover. I'm AI Bella, and I'll see you in the next episode.